So my Christmas this year was an unexpected, I'm just working out how to say, digital detox. I got home and realised there was no internet. So I read the Alan Turing biography by Andrew Hodges and read a lot of Turing papers as well. They're absolutely brilliant, clear, and visionary. And he foresaw, for example, things like the need for large buildings to host data, which we really haven't got grasps with until the very last few years. And he also said that eventually changes in technology require the use of efficient librarians to keep us in order. And I think we're probably at that stage now. He began his revolutionary introduction of technology back in 1947 with the introduction of the automatic computing engine, the very beginnings of modern computers. And in the same year, the Town and Country Planning Act was made, and it, again, in some ways was revolutionary as well. It defined development for the first time as something that needed to be regulated by public consent. And it also required local authorities to provide plans, development plans for their areas. At that time, I don't think many people connected Alan Turing with the Town and Country Planning Act. But here we are in 2020 with technology in every area of our lives, from the moment we get up and put on our Fitbit to the end of our day streaming something from Amazon. Unfortunately, the planning system has not modernised or evolved in anything like the same way. It is still really based on those 1947 principles, specifically a development that is purely physical, and also a paper-based process and a cumbersome paper-based development plan process. And I think things really do need to change. And I see that one of the key components of the Digital Cities for Change agenda is a new governance framework. And I do keep hearing this whenever I hear about a new proposal for development. They always say we need good governance, we need good data sharing and all the rest of it. And the framework itself of the Digital Cities for Change agenda says that you're going to incorporate legislation, regulation, sharing and security. But I look at the current regulation of the planning system, and I see that it's actually quite a long way behind the technological developments that we have. So what I'm going to do with this talk is highlight the need for change in 4 specific areas, and then look at ways, really practical ways, that it could be achieved. The first one is, I think, a reconception of what land is. We still think of the built environment, and when I say we, I mean the practitioners out there, the planners on the ground, the local authorities making their decisions, and the planning lawyers regulating them. And the reason we still think of things as physical is because the 1990 Planning Act has an unbelievably old-fashioned definition of land as a corporeal hereditament. And that sounds old-fashioned to me. I can't imagine what it would sound like to anybody, coming as a digital native to it. And it also defines development as a physical operation or a material change of use. And that material change of use is assessed as a physical change. But we all know now that every physical operation and every change of use has a digital shadow, a digital self that begins before the physical development and can last beyond it as well. So in a sense, we're at the stage where the digital self of a development is almost more real than the physical one. And not only that, but they are potentially interconnected. The homes are increasingly connected within themselves and to the outside world. They become increasingly connected not just to the land, but it's in accompanying infrastructure, things like roads, buildings, railways, cars. And I think we're at the time where we need to think of land not just as a piece of earth or a piece of built form, but a digital platform, in the same way that we now think of media as a platform rather than something that comes out of a television. Unfortunately, while the construction industry has adapted, you now have BIM adopted on a quite regular basis, the idea that you would have a built model, a data model. The planning system is really quite analog still. We don't even have a single data standard agreed, and planning applications are still submitted as bunches of paper dropped off at the local authority. I've also, unfortunately, within my profession, having stressed the need to become up to date with technology, I've had quite senior planning lawyers say to me, well, that's AMR. And I said, what do you mean AMR? And a couple of them said, after my retirement. So there's a certain amount of resistance within the profession as well. So how can we respond? Well, in the planning system, we already have environmental impact assessments where before you get permission for any large development, you would assess its environmental impacts, and you would put that assessment to the local authority with the planning application. And it would also have proposed mitigation measures, and the impacts and mitigations would be taken into account by the local authority when they make the decision to approve or not approve. And in parallel, you have data protection impact assessments, where you do, if you have a particular risk with your data, for example, you're going to be doing something that involves processing personal or sensitive data, then you carry out an impact assessment to make sure that you have mitigated your risks. And I'm saying that we should do something similar for data when we put an application in, one that looks at the impacts, but also the benefits, which is something that data protection impact assessments don't do. I'm definitely pro-data. I think there's an enormous amount of public good available that can be extracted from the data from a development. And as well as missing the risks, we're also missing out on the potential benefits of data by not grappling with it right from the start of development. So I'm promoting as much as I can the potential to have these data impact and benefit assessments that start to be adopted as part of the regular framework of documents that you would put in with a planning application. There's a lot of acronyms in planning, and this is one of the key ones, the GDMPO, which is the General Development Management Procedure Order. It sounds just about as dull as it is. It is an enormous document, 43 different articles, and it regulates all of the mechanics of a planning consent process, from however many plans need to be submitted with the application, through to where you post your notices on site, through to where you need to publish your application and how you consult on it. There are a number of problems with it because it is a 2015 document, but it is no more than an update of the original document that came out again in the 1940s alongside the Planning Act. And what's happened over the years is it's been updated and updated and updated, but it's kept that skeleton of its 1940s origins. So, for example, consultation is still assumed to be a paper exercise. There's reference to information, but no reference to data or even to a data standard. Sites are conceived only as physical things, and site visits are conceived only as something that can happen on physical land. Notices are assumed to be posted on the site or near the site or in a paper newspaper. And communications are assumed to be letters, and you actually have to have a kind of approval to use email for many of the communications under the GDMPO. So it is really out of date, and it needs a complete reboot. I mean, ideally, start from scratch and rewrite it, but that's not generally how things work. At the very least, it needs to be re-engineered as digital by default. And this is something that I'm actively campaigning for, but again, the profession is not really seeing the need for yet. However, we do have the Building Safety Bill, which is slightly becalmed now for other reasons, but is going to come through in the next couple of months, and that will implement the Hackett Review. And one of the things the Hackett Review will recommend, and this is the response to the Grenfell tragedy, it will recommend a golden thread of data to be held as a digital cache, and that will move through the life of the development. And this is the very first time that the government has regulated directly for data to be managed through and before the planning process. So we are on the edge of getting there. And I think it is time for the system to update itself and adapt to that. Second issue is automation. And this is where I was very excited by what I read, obviously through the Turing biography, but also the work that I've done with the Turing Institute on the way that automation is working its way into planning decisions. It is slowly hacking at the edges of the planning system. The validation of planning applications is starting to become automated. In addition, chatbots are starting to be adopted by a number of different local authorities, some of them in London, some outside London. And this is brilliant. It's a wonderful step forward. In addition, a lot of our environmental assessments now are based on empirical information generated automatically. And that is, again, really helping to assess the impacts of development. However, we have a number of concerns emerging, again, from the fringes. The Committee on Standards in Public Life issued a report earlier this year, which said that public authorities are introducing AI into service delivery without understanding the requirements of the law. And I think that's fair enough, because when you have AI and you have an algorithm, the more powerful it is, the less explainable it is. And that means you have, in governance terms, an opaque decision. And that means that it could be quite difficult for a local authority to explain the reasons for a decision. You might even say that it doesn't even have the power to make that decision because the local authority isn't making the decision anymore. And I think there are two risks that really do come out of this. Firstly, some local authorities will become aware of the risks and will simply say, we can't grapple with this. This is beyond us. Therefore, we will not take on this new technology, and they will miss out and keep on using resources for things that could be automated. And I think the other risk is that local authorities will say, fantastic, this bot is going to do the work of 3 officers. Let's adopt it. And then you will have a challenge because some clever lawyer has decided that that decision that was made partly by AI isn't valid. There are academics raising issues about the validity of AI planning decision making. And I'm also seeing a number of chambers with very reputable barristers in AI and human rights also raising issues. And, you know, we're in a difficult situation at the moment. There are a lot of hungry planning lawyers looking for work at the moment. And I think we need to avoid feeding them some easy meat in terms of these AI decisions. And I think it's possible to do this, because I'm old enough to remember when the Equality Act came in, which was 2010. At the time, very few planning lawyers thought it would be relevant until there were a few challenges on human rights grounds because the impacts hadn't been properly assessed or discrimination hadn't been taken into account. there were a couple of times when developments were stopped. There was a big market in Haringey where development plan proposals were completely quashed because they hadn't responded to equalities. And then the system sort of caught up, and now local authorities have equality strategies, they have equality impact assessments, and they generally take equalities into account as a matter of course when they're making planning decisions. And I'm saying that there's a way to do this now too with AI and with technology. There's a way that local authorities could adopt authority-wide strategic policies for automated technologies, and then have service strategies, service level strategies that are based on a risk matrix for different technologies, different risks, different functions. And then when you get down to the planning decisions, easily enough to have a protocol or an impact assessment. And this would mean that you would simply integrate, just like with data, integrate automation and the consideration of its implications into planning decisions, into development consents right from the start. The last couple of changes I'm only going to touch on quite briefly. The third one is engagement and consultation. This is much more relevant than I thought it would be, because at the moment the planning system is grappling with the problem of not being able to have face-to-face engagement. And consultation is a topic of great interest at the moment, what we can do electronically. And a lot of innovative solutions are coming through using Zoom, using engagement, digital engagement, using social media. The problem is that we have court decisions that say that e-consultation isn't entirely valid. Jules Pipe was at a briefing recently. He's the Assistant Mayor for Planning for London, and he said that he didn't think e-consultation would comply with the strategic requirements and the legal requirements. And this means that we are stuck. We're stuck in an analog age. We're not taking advantage of the technology that we have. And I would say this is an area where innovation won't be enough. We actually need the government to say e-consultation is a valid consultation. And I think the reason for that is that there's so much to be gained from going into the digital world for e-consultation. You can access not just the people it's going to impact now, but the people who may live there in the future. You can involve a much wider audience. But the regulatory system needs to acknowledge and validate digital consultation methods and responses. The government needs to advise on what constitutes a valid consultation, and that consultation needs to include the populations of the future as well as the present. I'm very much heartened by the fact that in a matter of 4 weeks, we have now gone from a parliament that sat close together on leather benches to one that meets by Zoom. I was reading Hansard yesterday, and they were saying it's the first time in 700 years of the history of the House of Commons that the proceedings could take part virtually. And even more amused to find that the House of Lords yesterday read prayers read by the Lord Bishop of Newcastle in a virtual proceeding via video call. Now, if we can do that with our Parliament, we can re-update e-consultations, I think, without much bother. And then the final change is the ethics around technology and planning and consents. Because as technology evolves, the divisions between the self and the outside world, between privacy and surveillance, are blurring. We already have case law looking at automated facial recognition. That's the Bridges case, which involved the South Wales police. That was, he lost round 1, but he's going back to the Court of Appeal to challenge that later this year. But on the other hand, in the COVID world, we're also recognizing the enormous benefits of surveillance and biometric technologies. Things like sensors that can recognize somebody with a particularly high temperature could be the way in which we're able to go back out into a world that looks something like the world we used to know, but still be safe. So it is not a matter really of stepping back from this technology. It is a matter of, as I said before, integrating it into the consent process so that we take both the benefits and the harms properly into account. The similar thing goes for equalities. I've been working with equalities in planning now for over a decade, but we have new issues as a result of technology. The first of those being the digital divide. The Environment Bill is also going through Parliament, and it has the first definition I've ever seen of a digitally excluded person. In addition, we also have an increased awareness of algorithmic bias, the way that if you train your algorithm on data that is out of date or biased in itself, then the algorithm is, in a sense, born with an embedded bias and carries on embedding that bias into its decisions. So again, with the planning system needs to adapt, it needs to take these new equalities issues into account. And I absolutely have the faith to know that we can do this, but it is a matter of really starting now. And again, from the House of Lords yesterday, Baroness Northover said, "I've had the privilege of joining meetings across the world that I've not had before, and in a way that it did not occur before. That is a huge benefit. There are new ways of working that I hope we will learn from in this circumstance." And again, you know, if the House of Lords can get to grips with Zoom technology in 4 weeks, there's no reason why the planning system can't expand to make sure that it takes these inequalities impacts into account. So my conclusions: public bodies really do need to assume that development of land and infrastructure is already disrupted by technology, and that resisting this or ignoring its benefits and its issues would be a real waste of time, and it's time we don't have to waste. But we do have a choice about how to respond. And I've been in planning long enough to see the system respond to all kinds of things, including environmental impacts, human rights, and then equalities. It will be, in each case, I've seen it respond retrospectively as a response to challenges from third parties. We have an opportunity right now to engage up front and build in the response, the way of dealing with the new technology, so that we can optimize it for the greatest possible human good and the least possible human harm. And I think it really is time for the rise of the efficient librarian.